Good evening, and thank you again for the invitation to come to speak to you at your annual general meeting. It's the third year that we've been invited to speak and address you on issues that are important to you and are affecting the membership of the association. Just before I get started, tell you a few things about our firm. We operate as the Labor Rights Law Office, and thanks to you, we've been practicing all across Canada, representing your members. We're a virtual law firm, which means we don't have a brick and mortar office where everyone goes to. All of our lawyers work from home, and we offer our services via web conference and telephone conference across the country. So how that works, for example, is this last Remembrance Day, there was a call placed to MPPAC's insurers seeking legal advice, and they approved the 2-hour legal advice on Remembrance Day, on the Friday. And after we got the notification of that, we set up the web conference and met with a member from New Brunswick to provide the legal advice on Sunday. So we're virtually there all the time. That's the advantage of having a virtual law firm. And the other advantage is, since we don't have high overhead, what we did was we reduced our hourly rates and passed that savings on to our clients. So we're client-centric that way. Now with me tonight is two other lawyers with the firm. First, Carlin Modeste. Carlin was here last year. Carlin has worked on a number of the RCMP cases, including the class action on the privacy breach. And one of our new associates, Mike Carter, is with us this evening. Mike is the same year as Call as I am. He just joined us last month. And there's two other members of the firm that aren't here tonight. Sherry Scher is an associate. She articled with the firm and has also been involved in a number of the RCMP cases. And because you've been keeping us so busy, we hired another lawyer who works out of Alberta. And he's a legal researcher with some extensive experience in defamation law. So those are the lawyers that work for the firm, and we've got what I say is 1 3/4 legal assistants. They're the only ones that work from an office. They work from an office in Coquitlam, and the rest of us work from the comfort of our home. A bit about myself. First of all, I'm a barrister and solicitor, and that's good news and bad news for you. First news part of that is that you're not paying me to speak here tonight. The bad news is that it used to be that the barrister quit talking when the money in the back pouch ran out, and he'd shut up and sit down. But since I'm not being paid, you don't have that kind of luxury. So here we are. I have over 30 years of experience in labor relations. A lot of it with unionized employees. I originally worked for a trade union in Alberta until I moved out to BC to practice law with Victory Square Law Office, where I became the managing partner eventually, and then left to set up this virtual law firm. And we did that 3 years ago, and since that time we've been assisting a number of RCMP members. Now, in terms of the topics that I'm going to cover tonight, I'm going to talk about the RCMP's, the new RCMP Accountability Act, Enhancing Accountability Act. I'm going to talk about medical discharges. I'm going to talk about code of conduct proceedings, and I'm also going to touch briefly on the grievance and appeal processes. So I'm going to start by first talking about accountability in the RCMP. And the first thing that I'm going to talk about may not be all that popular, but first I'm going to be fairly critical of the settlement that was reached for the female sexual harassment complainants in the class action lawsuit. The reason I'm critical of that is that the merits of the complaints will not be disclosed to the RCMP as a result of the process that's set up. So as a result, there's no accountability for the transgressors. They'll be shielded. The information's going to go to former Justice Bastarash and not turned over to the RCMP. So that lets the transgressors off the hook, and that's one piece of it. And the second piece of it is it also lets off the hook the managers who turned a blind eye to the sexual harassment that was going on and did nothing to change it. So since the facts aren't going to be disclosed to the RCMP, that's not going to be addressed. Those managers will continue to be in place and wander on until they enter into a happy retirement. The effect of that is that there's going to be no effective change to the culture within the RCMP as a result of that settlement. I'm also critical of what's being touted as the male harassment class action lawsuit. And the reason for that is that you need to understand a bit about how the law operates with respect to harassment in an employment context and how it's treated in the common law courts. And I want to be clear, first, I have no doubt that male RCMP members are being mistreated. We deal with matters affecting them every day. But the idea that there's a class action lawsuit for men is, in my view, a boon for the class action lawyers, but I don't understand how it's going to affect the individual members. First of all, at common law, there is no such thing as a cause of action for harassment. You can't go and file a lawsuit and sue someone for harassment. That isn't a cause of action known at common law. There is, in the human rights context, harassment's usually understood in the human rights concept because it's bound to discrimination on one of the prohibited grounds in the Human Rights Act. So you can have a complaint of harassment in the human rights context, but the courts have consistently said, including the Supreme Court of Canada, that harassment or discrimination is not a cause of action known at common law. And the next piece of that, even if you could identify a cause of action and say that it's harassment, harassment has to be based on an identifiable ground. So in the women's case, you could do that because you could point to women in the RCMP as being a minority. They were breaking into what's typical been a male bastion, and there was discrimination going on the basis of sex. That's clearly identifiable. That doesn't transfer necessarily for males. You know, as a white male, I can hardly say that I'm a class that's disadvantaged. I'm a member of a class that's disadvantaged. It's not true. And I don't think it's true for the majority of male police officers. So I think there's going to be a real issue in terms of not being a cause of action and there not being an identifiable ground, since most of police work has been predominantly male-dominated. So I think this idea of a male class action lawsuit on the tail of the female sexual harassment lawsuit is not necessarily a good thing, because if the same thing happens where the transgressors aren't held to be accountable and managers aren't held to be accountable, there's not going to be any culture change within the RCMP. White shirts are going to continue to protect white shirts, and that's not going to be of any help to the organization and the ordinary RCMP members that are on the street on a daily basis. Now, accountability and integrity are touted to be hallmarks of the RCMP. And to that, I take a look at this new enhanced accountability with the RCMP Act, and I say, are you kidding me? Come on, man. First of all, you have Commissioner Paulson, who during his watch has 500 sexual harassment complaints from female RCMP officers. Paulson still got a job. How's that enhancing accountability within the RCMP? Unbelievable. Come on, man. Anyone else would be fired. Happened on your watch? You're out of here. Not here. Next, we have the tragic situation, absolutely tragic, where RCMP members are murdered at Mayerthorpe and murdered in Spiritwood and murdered and injured in Moncton, and still, to this day, not every detachment has carbines, and there aren't sufficient members trained within each detachment on the use of carbines. That's shameful. Now, this was one of the recommendations that came out of the inquiry into the Mayerthorpe murders. The inquiry decision came out in 2011. That was one of the recommendations. The RCMP said they'd act on it immediately. And today we're still in a situation where those tools that you need in order to work safely have not been provided to you. Again, this happened on Paulson's watch. He's still got a job. Where is the enhanced accountability? So to that I say, come on, man. The RCMP has hired a law firm recently to defend, and it's the same law firm that defended disgraced Senator Mike Duffy. But the RCMP's hired him with respect to the 4 charges against the RCMP under the Canada Labour Code. So Duffy's lawyers are now going to represent the RCMP in defending against charges that they didn't take the appropriate measures to provide Moncton officers with a safe workplace. And Paulson's still got a job. I say, what's with that? Come on, man. And, you know, it's one thing to have these things happen, and you're the commissioner of the RCMP, and they happen during your watch, but to be the baby daddy of the Enhanced Accountability Act and have these things happen and still have your job? I say, come on, man. Where's the accountability? Internal reports by independent legal counsel and senior commissioned officers right here within E Division concluded that the RCMP members who responded to YVR and used the taser in the manner that they did so in accordance with how they were trained by the RCMP. However, the RCMP is hidden behind misinformation that was disclosed to the public that held these members out to dry, saying that they used excessive force, when that's not what the internal legal opinions and the internal investigation concluded. How's that enhanced accountability within the RCMP? And Paulson, that didn't start during his watch, but it continued during his watch. He's done nothing to fix it, and he's still got his job. And to that, I say, come on, man. There's so much wrong within the RCMP and the force decides that its biggest problem today is that there are a number of members who are injured or sick, and they have to get them off the payroll. That's Paulson's big project under the new Enhanced Accountability Act. Not the carbines, not dealing with the sexual harassment allegations and holding those managers and the harassers accountable, but to take on the sick and injured. Now, I recall seeing the video of Paulson speaking at a town hall meeting where he said, if you get sick and injured on the job, don't worry, we'll be there for you. We'll back you up. Well, let's take a look at what in fact happened in that regard after he got these new powers under the Act. Some of you may have read recently about a case out of K Division of a member who was at work and was relieved of duty, having finished his shift, by the members who then went into Roscoe's Quonset hut and were shot and killed. This member had been on shift overnight, tasked with watching Roscoe's farm to make sure that he didn't return. And the common belief is that Roscoe returned to the Quonset hut under the cover of darkness using a sheet. And since it was winter, he used a sheet to crawl back into the Quonset hut where he lay in wait for the RCMP officers to come in. And this officer, long-term employee. He worked 7 years first as a civilian employee, 19 years as a sworn member, and he had finished his shift, went home, lived in an apartment building where another member lived, went and had coffee with that member before retiring to catch some sleep before reporting to duty. The member he had coffee with got called in on overtime. He was one of the members killed, and he was a pallbearer at his funeral. He went off on sick leave, off-duty sick, and sought help and got counseling, got cleared to return to work on a graduated return to work. What did the RCMP do? They assigned him menial tasks, demeaning tasks, in order to force him to quit and move on to another career. He persevered. He tried to return to work, and as many of you may have experienced, the workplaces in the RCMP are not always welcoming to someone returning from sick leave. And that's what happened to him. He was ostracized by his peers to the point where he finally went off duty sick again. Now I can tell you his limitations are this. His only limitation is he cannot wear a uniform. That's the only restriction and limitation he has. Otherwise, he's fit to return to work. So what did the RCMP do? Well, they started under the old act to medical discharge him. They served him with papers that they were going to set up a medical board that was never established. They never sent him for an independent medical assessment. They had no medical evidence showing that he was unfit for duty, but they said they were going to medically discharge him. So he sat and waited for the medical board to be convened so that he and his doctors could challenge the medical discharge process. Then they got the new tools under the Enhanced Accountability RCMP Act that the commissioner gave him these new powers that allowed him to terminate members more easily by way of medical discharge. And so they sent him a letter saying, forget about the old medical discharge process. We're not going to go down that route with the medical board and all of that. We're going to use these new tools. We're going to go under the new act, and we're going to medically discharge you this way. So they have a superintendent sign a letter in this superintendent's opinion. He's not a doctor. Superintendent's opinion that this guy's disabled and should be medically discharged. They send it to the commander of K Division. She says she agrees with it, and they medically discharge him, cut off his pay. So much for Paulson's undertaking to the members of K Division that if you get injured on the job, we'll take care of you, we'll be there for you. They weren't there for this guy. Well, let me tell you what happened. This member came to us, and we filed a notice of judicial review for him. We also filed an appeal because we wanted to backstop the process, so the argument couldn't be raised that we didn't follow the internal appeal process, but our argument was going to be that the process is so flawed and so ineffective it's not a sufficient process that provides a remedy in a timely way to members. So we filed an application for judicial review to quash the order to medically discharge him. And we raised a constitutional argument. The constitutional argument was this. Under Section 20 sub 2 sub 1 sub G of the new RCMP Accountability Act, it allows the commissioner to discharge any member for reasons other than a contravention of the Code of Conduct, new provision that didn't exist in the previous code and the previous act. Then the commissioner came up with some new standing orders. One of the new standing orders was he defined what reasons other than a contravention of the code included. And he included in Section 6 sub A of the Commissioner's Standing Orders on Employment that means having a disability as defined by the Canadian Human Rights Act. So we said those two provisions together are contrary to Section 15 of the Charter. They're unlawful, they should be struck down and not enforced. And we filed in federal court because if we won there, it applied all across Canada and not just in BC. You know what happened 2 weeks ago? The government folded their tent. They agreed. But, you know, is this how the RCMP acts towards its employees? Is this the support that you deserve in the jobs you do? I say not. And while we got this member reinstated, he's going to be back on sick leave, and they've agreed to accommodate him or return him to work. But who's going to be held accountable? You know, certainly not the deputy, not the commander of K Division. It's not going to affect her. You know, these things go on, and management within the RCMP aren't held accountable for these kinds of things. Now, that's just one example of the type of medical discharges that are going on now. There are many, many of these kinds of cases. One here in E Division, we're representing a member who has a disability and needs accommodation. She can't return to work as a general duty officer, and the detachment commander told her that they didn't have a job for her in the detachment. There was nothing she could do, and they wouldn't transfer her out of the detachment to another job. Why? These are his words. I own you. I own you. Now, last time I checked, slavery was abolished. Now, what's peculiar about the RCMP is that normally injured workers can make application for WCB claims for injuries that occur in the course of their employment. That's true for police officers. For example, I represent the Port Moody Police Department. If a member there is injured on the job, like you, they are entitled to sick leave, but they also can make a claim for workers' compensation benefits. And while the benefits get paid to the employer, there's some services that come with that, like when you're fit to return to work, support and rehabilitation services in getting you back to work. That may mean physiotherapy, or if it turns out you can't return to your own position, it may mean retraining for another job that you can perform. But that's not available to RCMP officers. You're not covered by the Workers' Compensation Act. And so where's the gap? How is that filled? Well, traditionally, how this has worked is that police officers were considered to be public officers. And as a public officer, you couldn't be dismissed unless you were removed from office somehow. And that's why when a police officer is sick, they get 100% of their pay and benefits because they're a public officer. And that's why when a police officer is faced with being suspended pending an investigation, they get 100% of their pay and benefits while the investigation is going on. Because of this concept, the police officers aren't employees, they're public office holders. And that's traditionally been how police officers have been viewed. Now, with respect to RCMP officers, the employer is trying to turn this back, the RCMP is trying to turn this back and start treating individuals as employees that can have their employment terminated, even though the employer hasn't fulfilled its duty to accommodate an employee who has a disability. Now, there's other federal employees that we can look at and identify these kind of benefits. For example, in the armed forces, if you're injured on the job, there's these rehabilitation services, occupational rehabilitation services, are available through Veterans Affairs. But guess what? The RCMP didn't buy into that aspect of the Veterans Affairs program, so there's nothing. So you're left with medical discharge, no backup, and an employer who refuses to accommodate. Where's the respect and dignity that the RCMP has for its employees? If there's any group of employees that needs a union, it's you. Okay, another medical discharge horror story for you. Under the new act, the employer has another new tool called Employer Mandated Medical Assessments, EMMAs. Now, in law, an independent medical assessment, so-called, by an employer should only be done as a last resort. You know, the first thing you do is you ask the employee's doctor what restrictions or limitations the individual have. Are they fit to return to work? If the family doctor provides the medical information that the employer needs, that's the end of it. They should accept that, and the employee should be returned to work. If something more is required, if the employee needs to see a specialist, you ask the employee to see the specialist. And if the employee refuses and the employer still needs that information, and often in policing, the question is this person safe to return to work with a gun, right? You've been off with PTSD. They don't want to be liable with just returning you to work without having some kind of an assessment from a psychologist or psychiatrist saying you're fit to return to work. So in those types of situations, it may be reasonable if the employee hasn't got that kind of an assessment for the employer to seek an independent medical assessment. But the employer should first exhaust all other less intrusive means before they require the employee to submit to an employer-mandated medical assessment. Well, we recently had one where a member in K Division has been ordered to attend one of these employer-mandated medical assessments. And it is an order, it's a form of an order, so if she refuses, beyond a doubt, she's going to be charged with breaching the code of conduct. So our advice to her, go to the medical assessment. You have to go to the medical assessment. And while they can compel you to go to the medical assessment, what they typically can't compel you to do is to consent to be examined, because that's where it crosses the line. So you go to the assessment so that you comply with the order technically, but you withhold your consent, right? Now, in this instance, this member had been off not because of a mental condition, but because of a physical condition. So we don't have the situation that I described with the PTSD. She was off for a physical condition. She's now fit to return to work. Your employer is saying for an employer-mandated medical assessment. And so who do they send her to? Well, the RCMP, being the benevolent employer they are, send her to a forensic psychiatrist, Dr. Baxter in Calgary. And Dr. Baxter, on her website, says this is her special area of practice. She's a forensic psychiatrist who's been assessing and managing violent offenders, sex offenders, and severe personality disorders for the criminal justice system, law enforcement, and healthcare system since 2002. Can you imagine? Unbelievable. Dr. Baxter's CV does not disclose any training or experience conducting occupational rehabilitation assessments or functional capacity evaluations. But Commissioner Paulson still has a job.
That's where you should be going.
Yeah. I say, come on, man. So this started with health services, so we wrote a nice polite letter to health services pointing out that Dr. Baxter was not the appropriate person to do the medical assessment. Not that we were objecting to the assessment, because the member's been off for a long time and she's going to comply with the order, but Dr. Baxter's the wrong person. So we get a letter back saying she's got an order, she doesn't attend, she'll be exposed to a code of conduct. So we then raise it up a little, we write to the head of K Division and point out seemed to be lost in the health services office, that this forensic psychiatrist was not the appropriate person to make this assessment, and advised that if they proceeded with the assessment, that they could go ahead and do that. The member will attend, and we'll look forward to cross-examining Dr. Baxter on her qualifications to conduct this kind of an assessment. And if necessary, we'll refer the member for a proper assessment that we'll rely on for the purposes of defending the member. But this is the type of thing that's going on with these new tools. So the white shirts are drunk on this new power that they've got under the RCMP Act. Another instance that we had happen this year, we had an inspector here in E Division go to a member who was off for 3 days, ODS, and presented a medical certificate, sent a copy of it to his corporal, his supervisor, who passed it on to the sergeant. And the inspector, on day one, started texting the member, I want to talk to you, call me. So the member, he's off sick, I'm not fit for duty, I'll deal with it when I get back. Second day, they start calling. The third day, the inspector shows up at his house and starts pounding on the door. And the member answers the door and says, what do you want? I'm ODS. He said, do you want to do this out here, or are you going to invite me in? And the member says, well, I don't want my neighbors to see this, so come on in. So the inspector comes in with the staff sergeant, who's along with him, armed, in full uniform. And then the inspector says, so we're going to do this standing here in the vestibule, or you can invite us in to sit down? And the member says, here's fine with me. So the inspector then starts demanding, he said, well, why are you off sick? You look fine to me. You don't look ill to me. So do you have a mental problem? Do you have a psychological problem? Are you seeing a psychiatrist? What's wrong with you? And the member says, well, I've handed in a medical note, and I know it's gone to health services. I've been in touch with them. And so I've done everything I need to do. No, the inspector says, I decide whether you're fit to duty, and I can order you to report to duty. We no longer have off-duty MAD. So we file a complaint. And you know what the head of Human Resources in BC says? We're not going to initiate a code of conduct against the inspector. He just misunderstood his power. We'll deal with this as a performance issue.
Accountability there, right?
Yeah, enhanced accountability. So if it feels like the commissioner is outgunning for you, he probably is. And if he isn't yet, be thankful that it's not your day in the barrel yet. Now, code of conduct proceedings. We've seen a ton of these in the last year that have been commenced on the most spurious grounds. I'll give you one example. We had a member about 15 months ago who filed a complaint alleging harassment. She discovered the evidence that proved that who her harasser was, and she could prove that by the handwriting on some of the evidence that she'd uncovered. She took that handwriting and she went into her supervisor's desk while he was off work, took her file out of the desk, and took it to the sergeant. Said, look at this. Look at the handwriting here and look at the handwriting here. He's the one that's harassing me. Look at the names in my file. They're the same as the comments that were made against me. You know what they did? They gave her a code of conduct for going to his desk. Now, we defeated that. And 15 months have passed. She filed a harassment complaint. She just got a partial decision recently advising her that the complaints have been upheld. But that's the kind of things that are going on.
Mr. Anderson, there's a question from the internet.
Sure.
So the member wants to know whether or not he's obligated to attend the IME, even though health services has all reports from his specialist and their treatment plans to get him back to work.
Yeah, and the answer is if they don't attend the IME, they're setting themselves up for a code of conduct proceeding launched against them. So our advice consistently is go to the IME so you're not disobeying the order. But when you get there, the first thing that they're going to ask you to do is sign a consent form, and you can refuse and withhold your consent. And you say to the health services, look, I'm not refusing to provide you with information you need. Tell me what information you think you require that you don't have. And if it's reasonable, my doctors and my healthcare providers and I will provide it. If it's not, we won't. So.
Perfect.
Okay, just a couple more things before I finish up. First of all, there's a huge difference in terms of how these code of conduct investigations are conducted and the way harassment investigations are conducted. In a harassment investigation, they'll pick investigators who the RCMP have trained to be harassment investigators, and they'll run that file off the side of their desk. As a result, you end up in these harassment investigations that drag on for 15 months. Now, turn the table. Member gets a code of conduct. Oh, wait a minute. We'll assign someone from professional standards. They're out there. And the first thing they want to do is they want to meet with you. They want to get the member statement. Let's have an appointment right now. We've got this mandate letter. You've been served with the mandate letter. Let's set up the member interview right away. Well, we say, first of all, don't. First, get advice before you agree to go into any kind of a meeting. Because we've seen a couple of things happen at this stage. We've had instances where the member is dragged in and they do a lie detector test. Even though policy says that that's improper for a code of conduct investigation. They do it, right? This is kind of how they're used to operating, so they use all the tools that they can. The other thing that they're inclined to do when you go in to give a statement is they treat you just like you're an offender, and they'll do a video recorded interview. And I've had white shirts challenge me when I say we're not agreeing to a videotaped interview. Well, don't you want the best evidence? Frankly, no. Right? If it's good, I'll use it. If it's not, I won't. But we're not consenting to a video recorded statement. We're not dealing with an offender here. We're dealing with a member, right? So don't rush into participating in that assessment. And I know from dealing with cops that if you just get the opportunity to tell your story, someone will understand, and this will all go away. It doesn't happen like that. It doesn't happen. So don't meet with the code of conduct investigator until you get advice. Don't agree to submit to a lie detector test. The next thing is participation in the code of conduct investigation is voluntary. We've had members told that participation in the interview is mandatory. In fact, in one of the cases that we've had, the conduct authority used the member's refusal to participate in the interview as an aggravating factor when he considered the code of conduct measures. And we were successful on that ground, getting that, showing that was excessive. But that's kind of the mindset, notwithstanding it clearly says in the policy that it's voluntary. Now, I shouldn't be telling you guys anything. You're all cops. What's the effect of giving a voluntary statement? Right? It can be used against you in a criminal proceeding. So, before you give these kind of voluntary statements, think long and hard, get some advice before you do it. Now, maybe a little bit of a controversy on this last point, the standard of proof. Standard of proof in code of conduct proceedings is the civil standard of proof. Balance of probabilities. More probable than not the criminal standard. So in terms of the evidence that's going to be used against you, that's a standard that it's going to be assessed on. This case was a unanimous decision of the Ontario Court of Appeal, and it says that there's a third standard of proof, that the code of conduct evidence has to meet the threshold of clear and convincing. This case can be distinguished, and how it can be distinguished is the clear and convincing is the wording in the Ontario Police Act that applies to these officers that were involved in this case, don't apply to RCMP officers. You're not under the Police Act. So this decision only flows because it comes directly out of the Ontario Police Act, and that was upheld because of the specific wording in the statute. So you have to be very careful, because I was excited when I saw this case, because one of the cases that it talks about earlier on was a case that was decided in BC, decided poorly, I thought, by the BC Court of Appeal, because as a labor lawyer, we used to argue this all the time, that when the more serious the charges, and if the person's a professional or a police officer, then this clear, convincing, and compelling evidence standard ought to apply. And that was the law until the BC Court of Appeal decision, the one that's cited in this case that was distinguished. So I stand by my position. It's the balance of probabilities that applies. Now, and that's at common law. But what you have to understand with respect to the common law balance of probabilities is it isn't a fixed standard. There is a range depending on the nature of the allegation. So if the allegation is that you're consistently late for work, that falls at the low end of the range. If the allegation is that you're stealing money from the evidence locker and that you're a thief, that falls at the other end of the spectrum. But it's still the balance of probabilities. But for your immediate purposes, it really doesn't matter, because what you've got, you don't have a third-party adjudication process. This is being decided by white shirts, right? Not independent investigators. Now, if any of you had coffee with me, you'll know that I don't hold a lot of respect for judges. Most judges have never worked a day in their life, right? They sailed through university, typically on scholarships, ended up in law school because mommy and daddy was a lawyer or a judge, typically went through law school, got scholarships. Then when it came time to article, they looked at these big firms and went to article at the big firm and become an associate there, and then become a partner there. And one of the things with the big firms is they've got their own cafeterias, right? Because you don't want to have to go and have lunch with the unwashed, right? So here you've got judges making law that have sailed through their life with a silver spoon in their mouth, eating in private cafeterias where they don't have to deal with ordinary people. But guess what? Having a hearing before them is a lot better than having a hearing before any of the white shirts that make it your cases. So it's important to remember as you go through this process and you're thinking about a code of conduct proceeding, you're not dealing with a third-party independent adjudicator. You're not getting there until you're at judicial review. And I can tell you one example of, just in finishing up, one last case that we had. This was one that went to a level 2 adjudicator, and we argued that the member was charged with breaching a clear order, and we had very good arguments to show that the member didn't breach the order, and that the order had expired by the time the events took place. But all of that didn't matter to this adjudicator. He found that the discipline imposed was too harsh, but still a penalty was required. And in making that finding, upholding the superintendent, who was the conduct authority, upholding the superintendent's decision, he applied what's called the patently unreasonableness test. Now, the patently unreasonableness test was struck down by the Supreme Court of Canada in 2008 in a decision called Dunsmuir. And this patently unreasonableness test was typically used to protect decisions of third-party independent adjudicators or statutory tribunals. And what attracted this patently unreasonableness test is typically something called a privative clause that you find in the statute. There isn't one in the RCMP Act. But nevertheless, notwithstanding the Supreme Court of Canada had struck it down, notwithstanding that there's no privative clause in the RCMP Act protecting the decisions, he applied the patently unreasonableness test. And so we've got instructions to take that on judicial review. And it's important to attack this decision because this is the first time this has been decided within the RCMP regime, and it's really important that you get the correct standard applied. And we say the correct standard in this case, in the RCMP's case, is correctness, because the people who are making the decisions here are RCMP employees, and they don't stand in any better position than a judge in the court to make a determination as to whether the decision is reasonable. And so these are really important decisions. Now, if it wasn't bad enough that he said that in not one but two decisions, they don't send it to the member. And we find out because the detachment gets a copy of the decision that's been sent there, and the detachment calls the member and says, "Oh, by the way, there's some mail here from you for the Office for the Coordination of Grievances and Appeals." And we phone them and say, "Is there a decision out? Because we haven't got a copy of it. We haven't been provided with it." Well, there wasn't only one, there was two. One in August and one in early September. Notwithstanding we've been on counsel of record from the outset, we don't get a copy. So we're in the Federal Court of Appeal on that. So in conclusion, if you're faced with a code of conduct mandate letter, don't make any statements, admissions. Seek advice. If necessary, seek legal advice. You've got the association's legal insurer to assist with that. Don't surrender your notebooks upon receiving the mandate letter. Tell them you need to review your notebooks. They're their property, they're going to get them. But one, you need to refresh your memory and look at them, and you want to make copies of the relevant pages so that you've got them and can rely on them later on. So I know I went on a little long, Ray, but the money didn't run out yet. So, unless there's any questions? Okay, well, we're going to be around after, so if you have any further questions, feel free to approach us.
Sebastien has been with us on many occasions and has always been there to give us excellent advice, as you have all witnessed here. No words I could say can thank you enough from all of us, the members that are out there, that you've helped and assisted, and stuff that I've learned from you through Ray and that I've been able to give to membership. I'd like to present you just a small token.
Oh, very nice.
Sebastien, for all the recognition, for all the help that you've given us.
Great, thank you very
from all
much.
of us to